Over 100 years of racial discrimination had created intolerable conditions of inequality and deprivation for the black minority. At the heart of the problem was segregation. In 1954, soon after Warren's tenure began, a Negro child, Linda Brown, seeking admission to an all-white public school, brought suit against the Board of Education of Topeka, Kansas. The court's unanimous decision in this case was the first in a series of civil rights decisions which was to change the lives of black people across the country. It advanced a national ideal to eliminate racism. The lawyer who argued the case for the NAACP was Robert Carter.
The NAACP lawyers had decided to make an attack on segregation. And at the time, by 1950, which was the first argument I had made in the Supreme Court, a case was decided which held at the graduate level that segregation itself was a denial of equal educational opportunities. And on the basis of that decision, we decided in the NAACP that the time was ripe to make an all-out attack on segregation at the elementary school level.
Like millions of other black children in the South, Linda Brown had been denied entrance to the school under laws permitting racial segregation. In 1896, the court had condoned this practice with its separate but equal doctrine, which had permitted segregation in all areas of life in the South. Mr. Carter.
Chief Justice Warren writes simply, the decision was well understood, and he said that decision as beautifully as any judge could possibly have done.
Does segregation of children in public schools solely on the basis of race, even though the tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. The court's decision divided the country. White Southern reaction was angry and defiant. The man who argued more cases before the Warren court than anyone else, Jack Greenberg.
The Brown decision ran into such severe opposition, particularly from the southern states, that we had almost a series of minor revolutions on our hand. We had Little Rock and New Orleans. We had all the declarations of interposition and nullification. We had the Congress of the United States, or the Senate in any event, coming within a single vote of stripping the court of its jurisdiction. And during this period of time, that is shortly after 54 and 55, the court did very little with regard to implementation, except to sort of play its role in declaring that these revolutions, that is Little Rock and the like, could not stand. The educational effect of the court's work, however, was profound during this period of time, and what happened was what became known as the movement began. And the court played its role with regard to that. It protected those in the movement who were being arrested and clubbed by police and so forth, protected their First Amendment rights of free speech. And ultimately, the principles proclaimed by the court and the activism of the movement led to the passage of the Civil Rights Act of 1964 and 1965, at which point Congress and the executive branch, the president and the court, had all caught up with one another.
After the court ruled for the concept of school integration, it set out in 1955 to ensure implementation. It called for integration in public schools with all deliberate speed. This phrase was widely interpreted in the South as a signal that the court would tolerate delay, so the pace of integration was painfully slow. Eventually, the court became impatient with this open defiance and ruled in 1964 that further delays in desegregating school systems are no longer tolerable. In a recent decision, the court has provided strict criteria of compliance. For Jack Greenberg, it was another important victory.
In the last term of court, in case of Green against New Kent County, the court proclaimed that a desegregation order must work in order to be effective. It wasn't enough to have formal provisions like freedom of choice, which permit intimidation or permit the old habits of segregation to continue. In desegregating a formally segregated system, you have to have standards which actually bring about abolition of the previous two sets of schools. You have to end up with a single unitary school system. The Supreme Court essentially said was, look, we're not interested in excuses, it just got to work. And if you can't make it work any other way, and this is the way to make it work, well, this is how it's got to be.
Having said that the court's record in the race relations field is excellent, I have to make some modifications. One, I think that the court was in error in its all deliberate speed formula in terms of the implementation of Brown. The court had good reasons for doing this, but this is a part of what blacks are now complaining about. I think a part of the business that blacks are now complaining about, because what the court really did in that decision was to say that we will sacrifice the rights of the individual black child to equal educational opportunity and postpone it and put it off in order that this decision will become more palatable and more acceptable to the white majority.
The court's goal was racial equality. Its decisions have sought to eliminate segregation in virtually every area of life. It has ended the poll tax, which had been widely used to limit black voting. It has ruled against the drawing of political districts along racial lines. It has sought to prohibit all racial discrimination, both private and public, in the sale or rental of property. But its power to achieve full racial equality is limited by the willingness of the nation to comply. Thus, after 16 years, the court's goal remains unfulfilled. Once the court had addressed itself to equality of law for black and white citizens alike, its next task was to secure equal rights for the citizens of our cities. By 1962, critics felt that legislatures were grossly malapportioned in favor of rural areas. In a series of unprecedented decisions, the court said that federal and state legislative districts must be apportioned equally according to population. One man, one vote. The court had ventured into what had been regarded as the domain of Congress and state legislatures. Arthur Goldberg was Associate Justice of the court at that time.
It took a lot of judicial courage to cross that bridge, because the tradition had been that this was not a judicial matter. I was on the court when those cases were decided. It seemed to me, as it seemed to the chief and a majority of the court, that we could not justify that kind of decision. What can be more important in a democratic society than a man's vote? This is what our democratic society depends upon.
In the first reapportionment decision, Baker versus Carr, the court said it had the right to evaluate apportionment of state legislatures. In a subsequent decision, Reynolds versus Sims, the Chief Justice said, "Legislators are elected by voters, not farms or cities or economic interests. As long as ours is a representative form of government, and our legislatures are those instruments of government, elected directly by and directly representative of the people, the right to elect legislators in a free and unimpaired fashion is a bedrock of our political system." Senator Dirksen, a constant critic of the reapportionment decisions, is interviewed by NET's Paul Niven.
There isn't an iota of authority in the Constitution for the Supreme Court to apportion legislatures on that basis, and nobody knew that better than Justice Felix Frankfurter, because he scolded the court and said they had no business venturing into this legislative thicket. This was an invasion of the domain of Congress.
Justice Frankfurter's angry dissent to the Baker versus Carr decision. The court's authority, possessed of neither the purse nor the sword, ultimately rests on sustained public confidence in its moral sanction. Such feeling must be nourished by the court's complete detachment, in fact and in appearance, from political entanglements, and by abstention from injecting itself into the clash of political forces in political settlements.
Now then, people loudly proclaim, one man, one vote. What's wrong with it? I don't find anything wrong with it, except I find this to be wrong, namely that if a legislature wants to do it, it's quite all right with me. But I'm not going to sit idly by, if I can help it, and see the court do it.
Well, is any candidate for a seat representing a handful of people likely to come out for the abolition of that seat?
Well, the thing is a matter of balance in any state. And of course, you got rural and you got urban voters. Now, it could well be that a state is slanted in one direction or another in the apportioning of their legislature. But there may be some reason for it, too.
But the court's decisions were implemented with a minimum of delay and drastically changed the makeup of election districts across the country. In Connecticut, for example, before reapportionment, the town of Union, with a population of 383, and the city of Hartford, with a population of 162,000, had 2 representatives each in the State House. The new districts gave Hartford 10 seats and reduced Union to part of 1 seat. Legislators, fearing loss of their seats, were alarmed and critical of the decision. Connecticut State Senator John Lupton.
Perhaps the worst decision the Supreme Court has ever made, because there are minorities which need protection, which are not just minorities of people, minorities of local interests, rural interests, non-populous areas which need political protection, which is provided with proper safeguards to all the people by the reason of the fact that you have unit representation in one house, population representation in the other, and then the executive branch is elected by popular representation.
But the court discovered there was a problem in determining fair districts. Yale law professor Alexander Bickel.
If you don't somehow evolve some principle that explains what a fair district is and that enables the court to require the formation of fair districts and to prevent the formation of unfair districts. If you don't do that, it is quite apparent to me, and I think it'll soon be apparent to everyone, that to have simply said one man, one vote, districts must be equal, is to have said something at best trivial, something that has at best some symbolic significance, but which is in practice, in affecting the structure and operations of government, trivial, unimportant. Indeed, there is some evidence that it may be worse than that.
Even if a state is apportioned on the basis of equal population, you can still have political inequality. Here is how gerrymandering may be accomplished. Party A's strength is centered in the western third of the state, but statewide they are outnumbered by Party B. By the criteria of equal population only, A could end up with no representation, as in this example, or with 1 seat out of 3, depending upon which party was drawing the new lines. Professor Bickel feels the decision may make it easier to gerrymander in the future.
That a legislature that is told that it has to apportion on a perfect one man, one vote basis and is to disregard all other traditional indicia of apportionment, like county lines or what have you, that such a legislature is thereby freed, in a sense, more free than it would have been if it weren't under the one man, one vote mandate, freed in a certain sense to gerrymander in accordance with partisan political objectives.
All states now have reapportioned their legislatures. In this sense, it has been a great victory for the court, but many thought that the decisions might revitalize our political system, might save our crumbling cities. While there is some evidence that more urban-oriented legislation was passed by the new state houses, for most states, it is business as usual. Gerrymandering continues to be an effective weapon to maintain the status quo, and the court has declined to rule on this practice. As they had in reapportionment and race, The court continued to deal with the rights of the individual in its third major area, criminal justice. It found that the administration of the law, the technique of police interrogation, and lack of counsel for indigent defendants was hardly consistent with the Bill of Rights, and in decision after decision set out to protect the individual against abuse of power. The case of Gideon versus Wainwright. Any person who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. Miranda versus Arizona. Without proper safeguards, the process of in-custody interrogation works to compel the suspect to speak, or he would not otherwise do so freely. Escobedo versus Illinois. No system worth preserving should have to fear that if an accused is permitted to consult with a lawyer, he will become aware of and exercise his constitutional rights. Critics of these decisions voiced loud concern that the court was coddling criminals. Senator McClellan.
Increasingly, the court is fashioning exclusionary rules, the effect of which is to render inadmissible logical and positive probative evidence of guilt, including voluntary confessions. Unequal justice thus dispensed by the court in a number of these 5-4 decisions has trampled and disparaged the valid rights of society while magnifying and exalting fictitious and exaggerated rights of the criminal.
Ramsey Clark, former Attorney General and son of retired Justice Tom Clark.
The Supreme Court has to deal with the conflicts that our times create. And the conflicts between the poor in urban America and the police there are very real and very great. So they deal with such questions as the confession. What role does the confession play in law enforcement and in criminal justice in America today? The police have used interrogation, questioning, seeking to secure an admission or a confession in the 1950s and the 1960s, very much as they used it in the 1890s and the 1910s.
This prisoner was subjected to pre-trial interrogation that would now be outlawed by the Miranda decision. Here is a recording of that interrogation.
I told you what I done. I can't tell you anymore.
Did you bust that woman's ribs? Did you smash her face to pieces?
I know you're going to blow up on me.
No, I'm not.
I'd like to have my sister call a lawyer.
Are you going to be the goat? Are you the fall guy?
I'm telling you the truth. That's all I can tell you.
Isn't it much better to go up for manslaughter than to go up for murder number one?
The court ruled that confessions obtained in interrogations are inadmissible in court unless the suspect is first advised of his right to remain silent and his right to legal counsel. Many police officials feel this restriction will hinder their law enforcement efforts. Detective Russell Kruger, Minneapolis Police.
The more you talk to a man, the more he's going to admit. He's going to say more accidentally than he will on purpose. And especially if you start conning him, you're going to say, well, we want the police department cons men and tricks men, but what else do we have to fight with?
Why should I? I'm a policeman. Why should I risk my life in the dark alley or in the hallway or out in the street or in a chase with a car, 100 miles an hour, endanger my life, and then I bring you in, and there's your lawyer, and you walk out.
Ramsey Clark disagrees.
We know this, that the rich person charged with crime and the intelligent and the informed and the educated person and the hardened criminal and the organized criminal will not give confessions, have not given confessions, and are not going to give confessions, whatever the law says. Does this mean then that we have two standards? One for the poor, one for the ignorant, one for the person who doesn't know his rights, and the other for the wealthy, the advantaged, the informed, the person who knows his rights and knows how to protect them? The Supreme Court basically has said, no, we have one standard, equal justice.
It is no more than informing the general public.
Implementation of the court's decision took place on the precinct level.
A basic rule to remember is that all statements and confessions must be given voluntary. You must advise the suspect of his right to remain silent
The question remains, are most police forces complying with the court decisions? Ramsey Clark.
Most of the studies that have raised this question indicate that police compliance with the Miranda decision is far from perfect. In fact, in a number of jurisdictions, the indication is that the police are generally ignoring or disregarding the rule. That's intolerable.
While many critics say these decisions tend to protect the criminal, others feel the court hasn't gone far enough. University of Pennsylvania Law School professor Anthony Amsterdam comments.
The most important areas of criminal justice are the bail area, whether or not one may be detained in default of enough money to buy his release before trial. Adequate representation of counsel. The guilty plea, because 80% of cases go off on the guilty plea, and because if persons are held in default of bail, and if they don't have adequate representation by counsel, they will plead guilty. Sentencing, and then the probation and parole area. And in a case which goes through the process of the guilty plea, all of the Miranda and MAP in Ohio search and seizure decisions come down to nothing. They mean nothing. The defendant pleads guilty, he is convicted, and he is sentenced. Now, all of these important areas, which affect every case that go through, the Supreme Court of the United States has essentially said nothing.
There is great speculation as to what the new court will do amid the cries for law and order. Indeed, the new Chief Justice, Warren Burger, has already stated in a recent federal court opinion, this seeming anxiety of judges to protect every accused person from every consequence of his voluntary utterances is giving rise to myriad rules and exceptions which even the most alert and sophisticated lawyers and judges are taxed to follow. But that will be another court. For the Warren Court, it was years of response to human needs, a search for racial equality, criminal justice, and equal representation. In these concerns, the court may be said to have expressed not only the will of the law, but also the conscience of the nation.